I've been asked to discuss the recovery of attorney's fees and how that works and what the likelihood of that is in any one case if we become the prevailing party or we win the case. And it comes from a lot of different sources. There's a lot of different opportunities. And although we're optimistic, and I'll explain that in a minute about our ability to do that, I kind of want to explain a little bit about the various ways in which we may or may not get attorney's fees. For example, some contracts are silent and they don't say anything about attorney's fees. And if they don't, then you have to look to a particular, any relevant statute that may impose attorney's fees. And I'll get back to that in just a second. But a lot of times the contract itself says if we get in a lawsuit, the prevailing party gets their reasonable attorney's fees. So if it's in that contract, then we feel pretty good about it because we feel like we're probably going to be the prevailing party. Now, I do want to let you know that what's reasonable is up to the judge. We're going to say everything that we've billed is reasonable. And I've had a lot, and I don't know why judges do this, but they tend to sometimes maybe try to, I guess, throw the other side a little bone or something, because you'll prove up 50, 60, 70,000 in attorney's fees, and the judge would say, well, I think 40 is reasonable, and that's just what you get. Whatever the judge determines is reasonable. So there's the contract itself. Then there are statutes that apply that would also impose attorney's fees. I'll use Texas, for example. If you, it's called Civil Practices and Remedies Code, Chapter 38. It says in a breach of contract action, if it's a breach of contract case, then the winner gets their attorney's fees. And then there's the Declaratory Judgment Act that says if you have a declaration by a court that you owe money or don't owe money, or you're right or you're wrong, then the prevailing party in that may get attorney's fees, may get a reasonable attorney's fee. So those are may statutes. They can or they cannot. Most of the time, if you win, they do, but they're not mandatory. Then there are statutes that have mandatory imposition of attorney's fees. The Texas Deceptive Trade Practices Act and the Texas Home Solicitation Act both use the word shall recover attorney's fees if you're the prevailing party. So in those, you will, the judge is obligated to grant you your reasonable fees, but then again, the judge also is the one that gets to decide what's reasonable. So those are the various ways, either by contract, by statute, where it's permissive but not mandatory, or it is mandatory but also subject to the judge's discretion about what that reasonable number is. The way we do it is we keep track of all our time. It's called it's called the lodestar method, which is the right way to do it. And we keep track of all our time. We bill all our time, and at the end of the case, we've got one giant invoice for our entire bill. That bill could be $30,000. We had one case, it was $136,000. We've had one case, it was $80,000. I mean, it's all over the place. And if we did not believe there was some strong likelihood of us being able to recover those fees, there's no way we would invest $50, $60, or $100,000 into your case if we didn't think there was a good chance of getting them. At the same time, everybody needs to have their eyes wide open, is that there's always uncertainty in any litigation, and it may be that the judge says, I'm going to give you everything you want, but I'm not going to give you your attorney's fees, and arbitrations are final and unappealable. There's nothing we can do about it, but we do feel good about it. The vast majority of prevailing plaintiffs in other jurisdictions and in other arbitrations have been awarded their fees, and we don't think there's any reason for us to be any different. And I hope that helps explain prevailing party and what that means in terms of do we or do we not, is it mandated that we get attorney's fees?